the name of Almighty Allah, the most merciful. Now, today we will discuss the number of directorship and composition of board, that is board of directors, and we will discuss that under corporate governance rules, what is the framework given in order to ensure that the composition of board of directors is as per law. So let's start this. Let me invite Mr. Umar Amjad to do the reading of Regulation 3.
Number of directorship subject to the requirements of Section 155 of the Act. It is mandatory that no person shall be elected or nominated or hold office as a director of a listed company, including as an alternate director of more than 7 listed companies simultaneously, provided that the limit on directorship shall be effective when the board shall be reconstituted not later than expiry of its current term.
That's right. So you see, there is a limit given that a person cannot become a member of board of directors for more than 7 listed companies. And this embargo, this restriction is placed in Regulation 3 to ensure that the primary purpose of a director, when one is appointed as a director, he has some duties to perform. So if he is he is the member of board of directors for number of companies, let's say numerous companies, then of course he cannot perform his duties as per law and as mandated under the law. Hence this restriction that he cannot be the part of board of directors of more than 7 companies. This embargo or this restriction is placed in Regulation number 3 of Governance Regulations 2019. Now, when we discuss the composition, where the number of directors is one key area to be considered or to be taken care of, the second aspect is that what will be the complexion of the board, or what will be uh, in composition, whether that composition has to be of the kind in which it is diversified. People with different intellect, with different knowledge and background and qualification are accommodated. And gender is also one of the criterion we will go through. Let me invite Ms. Minail Amir to go through regulation number 4.
Yes, sir. Diversity in the board. The board shall comprise of members having appropriate mix of core competencies, diversity, requisite skills, knowledge, experience, and fulfills any other criteria as deemed relevant in the context of the company's operations.
Absolutely right. Let's say that the company is dealing with power generation. So the board of directors having that knowledge background will be given preference. If the company deals with textile sector, then of course someone who has that knowledge will be given preference. Likewise, if the company is a banking company, so someone who has adequate qualification in the field of business, finance, banking will be given preference. So actually, the competences is one of the basic requirement or the criterion in order to engage someone as a member of board of directors. In order to comprehend this regulation 4, let me ask Ms. Menail to read this regulation once again.
Yes, that comprise.
Ms. Menail, please read it again. There's some noise in your on your side.
Diversity in the board. The board shall comprise of members having appropriate mix of core competencies, diversity, requisite skills, knowledge, experience, and fulfills any other criteria as deemed relevant in the context of the company's operations.
That's right. So basically, in these competencies, diversity, relevant and requisite knowledge, experience is not the only requirement. This list is not exhaustive. There can be any other requirement which can help to look after the operations of the company in the most befitting manner. So, for that reason, any other competency can also be added in order to appoint or engage a person as a director for a company. Now we will move on to Regulation 5. Let me invite Mr. Temur Idnan to share Regulation 5 with us.
Representation of minority shareholders. The minority members as a class shall be facilitated by the board to contest election of directors by proxy solicitation, for which purpose the listed companies shall annex to the notice issued under subsection 4 of section 159 of the Act a statement by a candidate from among the minority shareholders who seeks to contest election to the board, including a profile of the candidates, to provide information regarding members and shareholding structure to the candidates, and 3, on a request by the candidates and at the cost of the company, annex to the notice issued under subsection 4, section 159 of the Act, an additional copy of proxy form duly filled in by such candidates.
Absolutely right. So let's say that you are having shares of Pakistan Petroleum Limited, and you are having 1000 shares of PPL, and in order to give representation to your stake, because you are one of the minority shareholder, in that capacity, you, in order to ensure your representation, this is the legal requirement that the company should invite those who are minority shareholders to become the part and parcel of board of directors. So the procedure is given. The candidate who is interested can be facilitated to solicit his candidature, to apprise the electoral college, the other stakeholders of that company. In this case, we are discussing Pakistan Petroleum Limited, that yes, I'm one most eligible to be your representative as a minority shareholder, and this is my qualification, which is exactly in line with the requirement of the company. This is my past experience, and this is how I can safeguard the legitimate, lawful, and legal rights of the minority shareholders. So this is how you can do your campaign. You can solicit your, in fact, electoral college to become the representative of minority shareholders in the board of directors. Let's move on to Regulation 6, and which is in fact further subdivided into 3 sub-regulations, and see that while discussing the composition of the board and its election, what is being discussed. We have just shared in Regulation 5 the representation for the minority shareholders. Now, Regulation 6 deals with independent director. Let me invite Ms. Fatima Hassan to do the reading.
It is mandatory that each listed company shall have at least 2 or more third members of the company, whichever is hired as independent directors. Explanation. For the purposes of this sub-regulation, a listed company shall explain the reasons in the compliance report if any
Miss Fatima,
transaction
I'm sorry
contained
for
in such
Miss
one-third
Fatima,
number which
I'm
is
sorry
not
for
rounded up as 1.
Miss Fatima, I'm sorry for
Independent
interruption.
director, the board shall be Yes, sir.
Yes, in fact, there was some signals issue on your side. So let's try it again. If you can read it, otherwise I am required to ask some other member to do the reading. So let's try again, Miss Fatma, if your reception is all right.
Okay.
I'm afraid, Miss Fatima, your reception is causing difficulty. Let me request Miss Iman Mujahid.
Independent Director, subsection 1.
Miss Iman, can you do the reading for regulation
Yes.
number 6?
It is mandatory that each listed company shall have at least two or one-third members of the board, whichever is higher, as independent directors. Explanation. For the purposes of this sub-regulation, a listed company shall explain the reasons in the compliance report if any fraction contained in such one-third number which is not rounded up as 1. For the purpose of electing independent director, the board shall be reconstituted not later than expiry of its current term. It is mandatory that the independent director shall submit his consent to act as director along with declaration to the company that he qualifies the criteria of independence notified under the Act, and such declaration shall be submitted to chairman of the board at first meeting, which is held after election of directors as well as on an event of any change affecting his independence.
That's right. Thank you very much. So for independent director, this is important that first of all, the ratio or the percentage that out of the total strength of board of directors, what will be the percentage of the independent directors? This is being discussed. The second very important aspect, that in case if there is a logical reasoning, and there is some lucidity in that reasoning, that the company cannot strictly comply with this composition for the independent director, the company is required to give explanation that these are the reasons or impediments that we are unable to act on this regulation, and and that has to be a logical reasoning in order to convince the regulator that the reason is genuine. And moreover, this is being discussed that the independent director, he's required to submit a declaration that he has no conflict of interest. He has no vested interest involved in the very company in order to act as an independent director. Because the very reason, the very logic that why in the board of directors there is a special arrangement made in the law that certain number of directors have to be independent persons. They should not have any uh, attachment, or their vested interest should not be involved in order to ensure that they render their opinion in a manner which is beneficial to the company, and they are not judgmental. They are not the one who are there to safeguard their own interests. So this is why a given number of independent directors are given here. Now, the next regulation deals with the gender actually. As I said, that the composition of board is not only meant for ensuring that people of all competencies are the part of board of directors, but also gender is also one of the criterion which is considered important. Let me ask Mr. Umar Amjad to share with us regulation number 7.
Female director. Subject to Section 154 of the Act, it is mandatory that the board shall have at least one female director when it is reconstituted after the expiry of its current term.
That's right. So let me ask Ms. Menail Amir that in the composition of board, do you think this is a good provision, and what benefits a company can get if there is a gender representation?
Yes, sir. So I think it is important to have a female director as well, because she might be able to, give out some laws which are in favor of the females, of the company. So that's why I think it is important.
All right. So if it is a textile sector, maybe she will introduce or suggest that Gul Ahmed must introduce new range of designs to attract the female customers. What do you think?
Yes, sir, exactly.
That's right. So you are a director of one of the company which deals with textile. What suggestion would you like to make to Spire that what kind of changes they should make in their designs? Yes, Miss Benail. Spire is a very popular brand, but do you have any, being a director of that company, to make any suggestion to improve the business of that company? Yes, Miss Iman, would you like to give your opinion?
So regarding the designs, the pattern, or something else?
Yeah, patterns, designs. You are a director of Spire, a textile company, and so what would you like to suggest them to improve their business?
I would suggest them to add new sizes, like sizes up to triple XL, for women who can't just wear other sizes and they have to get unstitched ones. So I would tell them to make clothes in bigger sizes as well, plus size
That's
as well.
right. That's right. You see, the women participation will have an advantage. Yes, I agree with that. It was just on a lighter note. So now the next regulation we will go through that deals with the executive directors. So, Ms. Iman, please share this regulation with us.
Yes, sir. For the purpose of compliance with the requirement of the above sub-regulation 1, the board shall be reconstituted not later than expiry of its current term. Explanation: for the purpose of this regulation, a listed company shall explain the reasons in compliance report any fraction contained in such one-third number which is rounded up as 1. Explanation 2: executive director means a director who devotes the whole or substantially the whole of his time, whether paid or not, to the operations of the company.
That's right. So these two explanation are meant for sub-regulation 2 of regulation 8, and these are meant for the executive director of a company. Now, this, in fact, on this point, I'd like to invite questions, the points we have gone through. So let's discuss executive director first. In order to move on, let's have this understanding that whether all the members of the class have understood these concepts well. Let me invite Mr. Raza Rahman to read Regulation 8 once again. Mr. Raza Rahman, I hope, I think he has some reception issue. Let me invite Ms. Hira Nadeem to reread Regulation 8.
Sure, sir. Regulation, sir, which regulation?
8,
Regulation
exact,
8. Sorry,
yeah.
yeah. Executive Director. Firstly, it is mandatory that the executive directors, including the chief executive officer, shall not be more than one-third of the board. Secondly, for the purpose of compliance with the requirement of the above sub-regulation, the board shall be reconstituted not later than expiry of its current term. Explanation 1. For the purposes of this regulation, a listed company shall explain the reasons in compliance report any fraction contained in such one-third number which is rounded up as 1. Second explanation is that executive director means a director who devotes the whole or substantially the whole of his time, whether paid or not, to the operations of
to the operations of the company.
That's right. Now, Ms. Hira, I have highlighted in red this explanation number one. We will read it again in order to assimilate the explain and compliance approach, that this explanation is absolutely relevant. So, Ms. Hira, let's read it once again.
Sure, sir. So it says that for the purposes of this regulation, a listed company shall explain the reasons in compliance report any fraction contained in such one-third number which is rounded up as one.
That's right. Now, for the executive director, if for the composition of board, a specific strength is mentioned, and in case there is a genuine reason that there is an impediment, there is a hurdle that company is unable to comply with that. So company is required to explain the same in its compliance report, that these were the impediments that we were unable to act accordingly, or we were unable to fulfill that requirement. Now let's have
Sir,
yes, please.
um, s- sir, if you can scroll up again, I couldn't understand one thing.
For regulation 8.
Yes, yes, sir. Sir, it's written at the last line basically that any fraction contained in such one-third number which is rounded up as one. What does this mean basically?
Yeah, look at, I mean, it varies from company to company. As you know, that we have a single member company, we have companies where at least 10 members board of director is the strength for the for composing a board. So if there is a board which has, let's say, 10 members requirement, and in that case, one third, in order to reach to that requirement, or if there are 7 members required and you have found one female director, you need a director representing the minority shareholders, then you need to have non-executive directors, then you need to have executive directors. So when you will go through the total number of board of directors, let's say that that exceed the total strength of your board of directors, then you can round off. But that, again, in that eventuality, which is very rare, the law has provided an explanation, because law is to cater for all seen and unseen situations. So in order to
Right.
make it comprehensive, this explanation is given.
Okay, sir. Okay, thank you.
You're most welcome. Right, composition of board was our topic of discussion today. And let me invite any question. We have been through the regulations which relates to the topic. As I said, number of directorship and composition of board, and regulation 3, which deals with number of directorship. Then we have regulation 4, which deals with diversity in the board. And then we have regulation 5 that deals with representation of minority shareholders. Then we have regulation 6, which deals with independent director. And we have regulation 7, which deals with the female director. And last but not the least is regulation 8 that deals with executive director. So we've been through these regulations and we have discussed them. If there is a question, I would be pleased to answer that.
Sir, I have a question in regulation number 3. Like, it's sort of a confusion.
Mr. Umar Amjad, you have a question for regulation number?
3.
Okay. What is your question, please?
So basically, it said that a director cannot be nominated unless he is, like, if he is acting as an alternate director for 7 other listed companies.
Yeah.
Now, the word alternate director, I couldn't understand, like, if alternate director, like, if he is already appointed for 2 other 7 listed companies, or just acting as a substitute in case of any mishap with the directors of those other 7 listed companies. Like, what does that alternate?
You see, in order to address your question, Mr. Umar Amjad, it's a very, very important question. in the composition of board of directors, we need to see that what law is available regarding the vacancy in the board. We have gone through Companies Act 2017, and we found that there are certain sections given which deals with the composition of the board. And this is also given that if there is a vacancy in case of death of a director, in case of default of a director, and if you recall, we have studied at length that that default can be on account of insolvency of the director, that can be a conviction by the court of law, that can be an activity which is illegal, and that very person is convicted by the court of law. So that in fact entail into default of that person to remain as a director. So if there is a vacancy, there is a time frame given in law that within a period of 90 days, for instance, that vacancy has to be filled in. Now, let's say that A is a person who is already attached as a director with 6 companies. He has an option to go for the board of directors post, member board of directors post for another company. But that list is not exhaustive. He cannot go for numerous companies or unlimited companies, because that will result into his failure to perform his duties. This regulation 3, Mr. Umar Amjad, is self-explanatory. I'd like you to read it again in order to understand it well. Mr. Umar, please.
Number of directorship. Subject to the requirements of Section 155 of the Act, it is mandatory that no person shall be elected or nominated or hold office as a director of a listed company, including as an alternate director of more than 7 listed companies simultaneously, provided that the said limit on directorship shall be effective when the board shall be reconstituted not later than the expiry of its current term.
Absolutely right. You see, this relevant section of Companies Act, if we will read section 155 and afterwards read regulation 3 of corporate governance regulations 2019, if we will read section and the regulation in harmony, we will understand that even the post of alternate director is considered as directorship. So you cannot say that, well, I am eligible, though I am with 6 companies already as a director, but and this 7th company, or you cannot say that I am a director of 7 listed companies, and I'm also eligible for this 8th company to be a director, because out of those 7 companies, I am an alternate director for 2 companies. You cannot exclude alternate directorship in order to be engaged for another company, because alternate directorship also require you to fulfill the obligations and duties as a substitute, and you cannot say that that alternate directorship is not equivalent to the whole directorship. That is actually, for this reason, for this regulation, that is considered an equivalent position, and resultantly, to the extent of 7, you can hold directorships of companies, and that limit cannot be exceeded. If it is, then of course there are penal consequences for that. Mr. Umar Amjad, is it clear?
Yes, sir.
Excellent. Let's conclude our session. If there is any question, I'll be more than happy to respond to that. Okay, it appears that it is pretty clear. Ms. Tahreem Nadeem, perhaps you'd like to ask some question?
Sir, can it be a director can be another company's director, which is both companies are competitor with each other?
Well, again, you see, this is very important to understand, Ms. Tahreem, that if there is a conflict of interest this is also one of the disqualification to become a director for a company, because you are here to safeguard the interests of the shareholders of the company uh, you see you are engaged as a director. So let's say that you have another competitor company. Let's say, let me quote an example. Service Pakistan has a competition with Bata Pakistan Limited. Now, on one hand, you are a director of Bata Pakistan Limited, and on the other hand, you assume the directorship of Service Pakistan. First of all, perhaps one of the company will not engage you, or the subsequent company will not take you as a director when they get to know that you are already on a board of directors of Bata Pakistan Limited. But on your behalf, in your case, you have to make a declaration that your assumption of this office will not create any conflict of interest. You are here to safeguard the vital interests of the stakeholders of your company. And this cannot be otherwise, actually. You are there to be beneficial for the company you have assumed the directorship for. And if it goes against this notion, then of course that you become unqualified or ineligible to hold the directorship of this company. Is it clear, Ms. Tahreem Nadeem?
Yes, sir. Thank you.
Excellent. So a good question. Thank you very much for your good questions and for your participation. Thank you again.